This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So it was almost a year ago that we talked about a dispute between a German artist or artist from Germany, Jonas Jödicke, and Aaron Carter, the American rapper, singer, songwriter, actor, dancer, and record producer, born in 1987. He was apparently a teen star back in the late 90s. A self-titled debut album in 1997 at age 9, which I was just blown away. I didn't realize he was that young. I mean, we talk about like teenage pop bands. He wasn't even a teenager at the time. But there was some kind of dispute over this artwork, this two lions with their heads together, and whether or not Aaron Carter had made some sort of illegal copyright infringing use of said artwork. So we have news now. Back in January, the whole thing blew up, and you'll see what the back and forth was, and you can also watch our previous video on it. And since then, Jonas has registered the copyright and filed a copyright infringement lawsuit back in August. Somehow I missed it back in August. I didn't catch it. I think I was in the middle of getting married and traveling to Luxembourg and then getting married in person again in like sort of a renewal of our vows thing, like literally 1 month later. So I might have been a little bit distracted. But now we have this update, and so let's look at the complaint, and then let's look at some of the remarkable things that have happened on the docket, because I think you'll enjoy this story. So buckle up, grab your popcorn, and let's see what's going on here. This is in the United States District Court for the Central District of California. Jonas Jödicke, plaintiff versus Aaron Carter, defendant. Jury trial demanded. Well, they didn't get that far. We'll see why. Plaintiff Jonas Jödicke brings this complaint against Aaron Carter, alleging as follows. Plaintiff is a digital artist. Aaron Carter is a rapper, songwriter, actor, dancer, etc. Looks like that was copied right from the Wikipedia page. This is a civil action seeking damages. The court has subject matter jurisdiction, personal jurisdiction, and venue is proper. We're not going to really worry about that. Plaintiff created the illustration Brotherhood on September 1st, 2015. He created the illustration in 12 hours using Photoshop on a Wacom tablet. On September 5th, 2015, he posted the copyrighted illustration to Instagram. And then apparently on January 17th, 2020, defendant copied and posted the copyrighted illustration to his Twitter feed, which you can see here no longer contains the copyrighted illustration. Defendant used the copyrighted illustration to advertise the sale of hoodies available on aaroncarter.com. He has approximately 620,000 followers, so plaintiff notified him on January 18th, 2020 of the unlicensed use of the copyrighted illustration. Carter responded by refusing to remove the copyrighted illustration. Plaintiff registered the copyright February 26th. On March 20th, defendant copied and posted it again. Defendant used the copyrighted illustration as a profile image. In all instances described above, defendant copied and posted the copyrighted illustration without license nor permission. So, plaintiff Jonas Jödicke, sorry if I'm pronouncing that wrong, but I'm trying my best here. He says he's the copyright owner, he has exclusive rights, he has not granted permission or consent for the copying and the public display, and so he alleges a count of copyright infringement, direct infringement. He has alleged a count of contributory infringement, that he knowingly made the copyrighted illustration available to third-party publishers like Twitter, and that he doesn't have permission to do so either. And then he alleges a count 3 of the removal or alteration of copyright management information, which is basically when you fail to attribute the author of the work. That's part of the DMCA. We've gone over that a couple times. Leibowitz likes to allege Section 1202 violations. So wherefore, plaintiff prays for judgment and wants an injunction preventing Aaron Carter from using it, ordering an accounting which is something you're allowed under several different laws, but definitely in copyright. If someone has profited or gained from use of your copyrighted work, you can demand an accounting. They want actual or statutory damages, which is going to become part of this later in a moment, and then costs and attorney's fees and all other relief, and a jury demand. And so here's the exhibit of the original artwork. Here's how it was posted on Instagram, and I guess, yeah, I think that's a direct screenshot of is that Safari? Instagram page. Here is the facebook.com/JoJo's art copyright notice that is on, it's down here, if you can see my cursor. And then here's how Aaron Carter used it. Two lions at war can reach an understanding. I have my lion's den, you have yours. Hoodies are back up on aaroncarter.com. And then Sharon Frost down here says, the artist is JoJo's art, in case you didn't realize. And he's tagged, so that's how he figured it out. And then here you can see Aaron Carter's Twitter using the two lions in black and white in his profile image. And so then Jonas Jödicke writes, hey, Aaron Carter, you are using my artwork to promote your merchandise. I have not given you permission to do so. My art is being commercially exploited by people on a daily basis. We artists have rights too. I'd really appreciate if you could retweet this so he'll see it. And then he replies, you should have taken it as a compliment. And then he calls him a name, because, that's mature. A fan of mine sent this to me. Oh, here they go again. The answer is no. This image has been made public, and I'm using it to promote my clothing line at aaroncarter.com. Guess I'll see you in small claims court. And then he misspells another expletive. So this is a plaintiff's lawyer's wet dream here. He basically admits he's using it, and then admits that he's using it to promote his clothing line. So there's no defense any further, really. I mean, you could go to court and you could say, oh, I didn't mean that. But you're already on your back foot. You're already off balance. The court is already being convinced because you have literally admitted liability. There is also a hearsay exception in evidence rules that allows admissions against interest. If I say to you, I did the thing, you can go to court and say, he said he did the thing, even though I'm saying someone else said the thing. Normally that's hearsay. I can't present evidence of what I heard, only evidence of what I know firsthand. But I can present evidence of what someone else, especially the opposing party, what they told me, if it is an admission against interest. Aaron Carter then doubles down and says other nasty things, potentially defaming things against the artist. But it appears we didn't have an Elon Musk defamation lawsuit about that. So then here's the copyright registration for the title of the work, Brotherhood, September 15th from Germany, and it's listed all there. Here is the profile picture from Aaron Carter's Twitter profile, and that's the end of the complaint. And that was filed back on August 31st of 2020. And then here is the court docket showing what has happened since then. So the complaint was filed August 31st, and the summons was issued very shortly thereafter on the 2nd of September. Apparently there was service on the 3rd. Aaron Carter was served on the 3rd. And then 21 days later, there's no response. And so the judge enters an order. The court, on its own motion, orders plaintiff to show cause in writing before October 5th why this action should not be dismissed for lack of prosecution. As an alternative, the court will consider the filing of one of the following: on or before the above date as evidence of the matter being prosecuted diligently, an answer by the defendant, or plaintiff's application for an entry of default pursuant to Rule 55A of the Federal Rules of Civil Procedure. So then on October 5th, application for clerk to enter default against defendant Aaron Carter. So that means that Aaron Carter was properly served The proof of service was put on the court docket. More than 21 days later, Aaron Carter had not responded. You can respond by asking for more time. You can respond by answering the complaint. You can respond by making a motion to dismiss or a motion for a more definite statement, but you can't not respond. So Aaron Carter was so sure that he was allowed to use that Two Lions Brotherhood drawing. He was so sure that he just didn't defend himself in court, which makes no sense. That's the opposite of what you would do if you were so sure. So it seems like there was a little bit of, immaturity in his answer, in Aaron Carter's answer on Twitter, and then sort of a realization that he had no legal standing or no legal argument, no grounds to oppose the lawsuit. And that's kind of okay, because if he went through an entire legal process trying to defend himself after he's already basically admitted that he's liable, well, there's two parts to a copyright lawsuit. There's the up or down, yes or no on copyright liability, and then there's the damages phase. And you can sort of do this in two parts. I wouldn't recommend it be done this way, but you could do this in two parts. You could default on the up or down liability, and then you could join the lawsuit for the damages assessment. And that is apparently what they've done. So on October 7th, the clerk enters default. The judge then starts to consider the default judgment. Default and judgment are two separate things. Default is the failure to respond. The judgment is then entered when the judge considers what the final damages judgment should be. So then on October 15th, attorney David Deal appears pro hoc vice, for this time only, for Aaron Carter, and the judge here's the motion for default judgment brought by the plaintiff, Jonas Jödicke. So what we're going to look at today then is the opposition filed by Aaron Carter's attorney against the motion for a default judgment. And the reason why we don't have to cover the things in between is because the opposition does an okay job of summing up what the problem is. And then we'll look at the response, and then we'll wait to see what happens next, and we'll make a follow-up video. So here is Aaron Carter's defense or opposition to the motion for the default judgment. Defendant understands that on a motion for default judgment, all of the factual allegations in the complaint are taken as true, but the damage allegations are not. In plaintiff's motion for default judgment, he asks the court to award $150,000 in statutory damages for copyright infringement, as well as attorney's fees, despite the fact that the alleged infringement commenced prior to him securing copyright registration. Therefore, he is not entitled to statutory damages nor attorney's fees. Further, plaintiff's attorneys appear to have filed false declarations regarding their time spent on the case and their hourly rate. So the issue is only going to be an argument over the money at this point. We know that Aaron Carter is liable, has committed copyright infringement, did not respond with a defense. So we've closed the case there, and now we're just going to argue over what the damages should be. Aaron Carter says, in their motion for default judgment, plaintiff makes the rather amazing claim that he is entitled to both actual damages and statutory damages for the same offense, Carter's posting of his drawing on Twitter. This argument is unfounded because Section 412 of the Copyright Act mandates that in order to recover statutory damages and attorney's fees, the copyrighted work must have been registered prior to commencement of the infringement, unless the registration is made within 3 months after the first publication of the work. In the present case, plaintiff concedes that he did not register the drawing before the infringement commenced. However, plaintiff argues that because Carter posted the image a second time after he secured registration, that he is now entitled to statutory damages because of an alleged second infringement, but he cites no case law to support this position because none exists. In fact, William Patry stated this is an argument deserving of Rule 11 sanctions, which is Patry on Copyright, which is a treatise and not case law. In the Derek Andrew case, the Ninth Circuit held that the first act of infringement in a series of ongoing infringements of the same kind marks the commencement of one continuous infringement under Section 412. As we have two infringements of the exact same kind at issue in this case, namely using plaintiff's drawing in a tweet, there is no question that this case involves a series of ongoing infringements of the same kind. In the same case, the defendant was a store that sold clothing that used hang tags that infringed plaintiff's copyright. Some of the sales occurred before plaintiff had secured copyright registration, and they continued after plaintiff obtained a registration. At trial, plaintiff obtained a default judgment against defendant, which included $15,000 in statutory damages because defendant distributed clothing bearing the infringing hashtags after the copyright registration date. On appeal, the court overturned the award of statutory damages, finding that the plain meaning of the statute indicates that statutory damages are not allowed under these circumstances. The plain language of the statute does not reveal that Congress intended to distinguish between pre- and post-registration infringements. Every court to consider the issue has held that infringement commences for the purpose of copyright when the first act in a series of acts constituting continuing infringement occurs. And then they cite to Whelan Associates versus Jaslow Dental Lab. Indeed, if the incentive structure of Section 412 is to be properly applied, Andrew, having waited nearly 2 years from the date of first publication to register its copyright, should not receive the reward of statutory damages. Accordingly, we join those circuits that addressed the issue before us and hold that the first act of infringement in a series of ongoing infringements of the same kind marks the commencement of one continuing infringement under Section 412. This interpretation, we believe, furthers Congress' intent to promote the early registration of copyrights. And I'm not sure whether I agree with their assessment that they really are one continuous act of infringement, but I do agree that copyright should be registered right away, at least within 3 months of first publication, so that you can preserve your right to statutory damages. Of course, that means you've got to spend $55 or $65 per copyright that you want to register. So I think there's a proposed thing for registering an entire album at one time, but that's just a proposal right now, and it hasn't been incorporated into law yet. In the present case, plaintiff waited over 4 years to file for copyright registration. Plaintiff is not entitled to statutory damages. It should be noted that the Premier Tracks versus Fox Broadcasting Company case, Your Honor cited Derek Andrew approvingly. So this is a really good citation here. The attorney is citing to a case that this judge decided. So that's like, it's like reminding the judge, like, we know how you ruled in the past. That's a good thing. You want to remind the judge, like, you made this decision in the past. You shouldn't stray from your decision in the past. Your Honor cited Derek Andrew approvingly in granting Fox's motion to dismiss Premier Track's claim for attorney's fees and statutory damages. If defendant is relieved of his default and makes a similar motion, there is no doubt that this will be granted as well. Because plaintiff did not register the drawing prior to commencement of the infringement, he is not entitled to statutory damages. It's also claimed that the attorney's fees are grossly overstated. Plaintiff did not register, therefore he's not entitled to attorney's fees, but nevertheless, in the event the court decides to award a reasonable attorney's fee, plaintiff's 3 attorneys filed declarations which appear to greatly inflate their normal billing rate. Yet this is something that you have to be careful of. There are rules, both in case law and in actual rules of professional conduct, the integrity and ethics rules of the legal profession, that attorneys are not to charge a excessive fee. Attorneys can only charge a reasonable fee. So Michael Reese filed a declaration stating that his normal hourly rate is $950 an hour. It sounds a little bit excessive for a basic copyright case. Ranges of $400 to $500 an hour are pretty normal. $300 an hour would be basically accepted outright. Anything less than that should be completely normal. I don't understand how we got to $950 an hour. That would be for the most experienced attorneys in the most complicated cases, really is what I would expect that would be. George Granada, whose experience is not listed, who's with an apostrophe S, there's a mistake there, bills at $850 an hour. This is despite the fact that neither of these lawyers appear to have any expertise in copyright law, and their website does not even list copyright as a type of case that their firm regularly handles. Nor does Mr. Reese's declaration break down how his time or Mr. Granada's time was spent on the case, or why a case which solely involved the filing of a complaint and a motion for default judgment took 3 attorneys 31 and a quarter hours. On its face, without seeing their response, that does seem excessive for a case with very simple facts. I understand it's copyright and federal, but that doesn't buy you $950 an hour as far as I can tell. Mr. Reese states that his fees have received court approval and cites to La Chamba versus Capital One Bank. Mr. Reese does not cite to a document in the record, but a review of PACER records shows that this is a class action lawsuit against a bank. There is nothing to indicate that fees for such a case would be comparable to a copyright infringement case involving one drawing and an admission of liability in a default judgment. Just saying, that's easy street. That is not super complicated. Nor does Mr. Reese declare that $950 per hour was the rate he was charging Mr. Jödicke for his services. Although I think we have some lodestar factors are, I'm not familiar with this case. I have to look it up again. But the lodestar factors do mean that you bill. You can charge the attorney's fee for the appropriate rate, not just what you billed your client. So in other words, my understanding is that if Mr. Jödicke is being charged $100 an hour, that doesn't mean that the attorney's fees can only be $100 an hour. They are the lodestar rate, or the reasonable rate for an attorney practicing in that case, in that region, in that area of law. So although I think $950 an hour is excessive, hypothetically, if Mr. Jödicke is being charged $100 an hour, Mr. Reese could still charge $400 an hour to the opposing party on an attorney's fees claim. Mr. Deal's declaration is more troubling. He states that he spent 18 hours working on this case, again without giving any breakdown, which you are supposed to give a breakdown. That's how you preserve your right to attorney's fees. And states that his hourly rate is $750 an hour, although his office is in a small town in Crozet, Virginia, population 6,500, and he has only been litigating since 2015. Furthermore, in 2 declarations filed in conjunction with copyright cases Mr. Deal filed in Virginia, Mr. Deal previously stated under penalty of perjury that his fee was $200 per hour in 2017 and $250 per hour in 2018. It is impossible to believe that Mr. Deal's normal billing rate has gone up from $250 an hour in 2018 to $750 an hour in 2020. If that's true, it does seem like someone is trying to just charge opposing counsel an excessive fee in order to recover a windfall from the case. Accordingly, it appears that plaintiff's attorneys have grossly inflated both their normal fee and the time spent on this case, although defendant believes that plaintiff is not entitled to any attorney's fees. In the event the court does award attorney's fees, the fact that these attorneys appear, again, no apostrophe necessary, the fact that these attorneys appear to have lied about both their billing rate and the time spent should mitigate against any attorney's fees being awarded. This is a very small copyright infringement case involving a drawing that was shared on Twitter. Plaintiff's best case is that he suffered only about $6,000 in damages. There is nothing in the record that would indicate that this case is worth more than that. So that sounds to me like they're offering to pay $58.75 in damages. I don't know. I would take that if I was Jonas, but maybe there's some evidence that the infringement was more widespread than that. Maybe take the $58.75 plus a public statement from Aaron Carter apologizing and linking to Jonas's art. On the other hand, let's not forget that there's a claim for actual damages plus Section 1202 misuse or removal of copyright management information, which is also another set of damages that I don't think depend upon the copyright registration. So then we have Mr. Jödicke's attorney's reply, and they say, in opposing plaintiff's motion for default judgment, defendant makes arguments that are not supported by evidence, are irrelevant, or include misstatements or omissions. So, everybody's lying here, apparently. Therefore, default judgment should be granted. Defendant's arguments break down to the following. Plaintiff is not entitled to statutory damages, and plaintiff's counsel are not entitled to their fees. Both arguments are wrong. Defendant, after mocking plaintiff and the judicial system, and blatantly ignoring this case until the 11th hour, has made assertions that are both legally incorrect and which run directly counter to statements made by defendant himself. Defendant incorrectly argues that there is one date of infringement, not two, and therefore plaintiff is not eligible at all for either statutory damages or attorney's fees. Defendant blatantly omits the fact that plaintiff, whether this court determines whether he is eligible for statutory damages or attorney's fees, is clearly eligible for statutory damages and attorney's fees. To start, defendant falsely states the law regarding timely registration and corresponding statutory damages. In addition to the requirement that a copyrighted work must be registered prior to the date of infringement or the date of registration is within 3 months of first publication, a copyright holder may also recover statutory damages if the date of registration is within 1 month of the date of infringement. This is a complicated statute, and it is easy to misread the timing of all of that. So there is some law and case law for recovering statutory damages if you register right after the infringement occurs. Additionally, defendant has made clear statements concerning the circumstances of his unauthorized copying of plaintiff's illustration at issue in this case. On January 18th, defendant stated, "You should have taken it as a compliment. A fan of mine sent this to me. I'm using it to promote my clothing line. Guess I'll see you in small claims court." There was no small claims court at that time for copyright. There is now. The CASE Act has been passed as part of the COVID relief bill and omnibus spending bill at the end of last year. So go take a look at our video on what the CASE Act entails. I'm also planning a collaboration with Richard Hogue. That's not set in stone yet, so I hope to have that happen, and I'll be contacting Attorney Hogue, and we'll discuss the CASE Act and the Felony Streaming Act bill alterations that were included in there. I'll link to those things as well. Then on December 4th, 2020, moments after being served with the documents concerning the previously scheduled motion for default judgment, defendant stated, Jonas wants to sue me because I found an image on Twitter. So again, just admitting liability outright. I did it, officer, and then going and hiring your attorneys to try and defend you after that is not a recommended course of action. Based on defendant's own statements, defendant copied copyrighted illustration not once but twice. Once after he received a copy of the copyrighted illustration from a fan, and a second time when he downloaded a copy from Twitter. Defendant's unauthorized uses of the copyrighted illustration were the result of two distinct incidents of copying. The first incident took place on January 17th. The second took place on March 20th. The first incident is subject to actual damages. The second incident is subject to statutory damages based on plaintiff's timely registration. Plaintiff may elect statutory damages for the second incident of infringement because he registered the illustration before the date of the second incident of infringement. Additionally, the date of registration is within 1 month of the date of the second incident of infringement. Defendant twice copied the illustration and twice removed plaintiff's copyright management information from the illustration before posting it. Section 1203 permits this court to award up to $25,000 in statutory damages per incident. 1203 also permits this court to award attorney's fees. Given defendant's initial and now continuous disregard for plaintiff's copyright, see this video recorded by defendant December 4th. Let's take a quick look at that.
I gotta go work anyway. Nice to meet you, process server. December 12th. Jonas wants to sue me because I found an image on Twitter, posted it, said brothers can get along, and put my website on there. I didn't know that was a crime, but I guess it's copyright problem. I guess you can't put somebody who sends you a picture on Twitter, a different fan, it's like, oh, you would love this, and I use it, and I just was like, I put up one tweet, and then these people came in, so. And then he got me in Forbes, so I'm gonna fucking hit him with a defamation lawsuit, and he also tried to extort me and say, just buy I got a DM from him. I'll just buy one of my $10,000 paintings and I'll let you go. Like, are you gonna let me go? I'm not denying the artwork wasn't amazing. That wasn't it. You don't come at me a certain way. Like, that's just how it works, man. watch. I will go in there. I have all, like, it's a complete misunderstanding, but don't come at me a certain way and try to blackmail me and then say you're gonna, and that's not how it works. What you gonna get? You're not gonna get anything. I told you that. I told your attorneys out on the phone and say you ain't gonna get anything. I'm gonna slap you guys with a lawsuit. It's gonna be bigger. So, but he's going for it, so let him go for it. And I'm going in and I'm representing myself. I'm gonna litigate the suit myself. The photo was also posted on Instagram, which means then Facebook owns it. Entrapment? No, it's not entrapment. It's called blackmail. Could be entrapment. It's actually quite a few different things. Defamation, slander, blackmail. It's bam, bam, bam. So you're going to hit me with that, and I'm going to hit you right back. And then I'm going to drain you in court.
Okay, so there was a lot there to unpack. First, blackmail, no. Extortion would be if there was no underlying copyright claim. Sending someone an image on Twitter does not mean that you now own the image. The fact that Instagram or Facebook or Twitter have their own license doesn't mean that you have the license. Maybe there's some argument for retweeting or something like that, but that's not what he did. He did not retweet the image, as in retweeting an image from Jonas's Twitter by going to one of Jonas's tweets and retweeting it and saying, hey, I like this. Instead, he copied the image and posted it as his own and apparently, or allegedly, removed the copyright management information. So again, all of that is a defense attorney's nightmare and a plaintiff's attorney's wet dream. He basically admitted everything and also showed major disrespect for the court system and the court process. And while not directly contempt of court or anything, I don't think the judge will look upon that sort of attitude very favorably. Also notice how he said he's going to win and he doesn't need to hire any attorneys, and then he starts practicing publicly what he's going to say to the judge. Don't ever do any of that. This is why so many companies, police departments, attorneys just say no comment. We don't comment on pending litigation. Why don't you comment on pending litigation? Because someone's going to admit something that they shouldn't admit, and then they're going to have to defend themselves in court. I don't know if you guys remember the fake cop incident, and I went online and I posted about the fake cop incident. And then when we got to the arraignment, I got cross-examined for 3 hours about that. Do you think that maybe next time I'll think about when I'm going to post something and wait until after the arraignment and after the trial before I post about it? Maybe. But that's why, because now he can be cross-examined about this. This evidence can be used against him in court. He is not going to be succeeding in a defamation claim. First off, there's a part of defamation where you need to actually damage the person based on a false statement. So you'd have to point to a false statement by Jonas Jödicke, and Mr. Carter would have to show the actual measurable damage. You can't just point and say, I got some pushback on Twitter. You have to show how a false statement resulted directly in lost money. So that's probably not a defamation suit, even if there was a false statement, but there's also not a false statement here that I can immediately see. Definitely not extortion to make a legal claim through the legal system over a copyright that is obviously owned by Mr. Jödicke. So not extortion. Blackmail, not even close to blackmail. I think Mr. Carter even acknowledges that it's not capable of being blackmail. It sounds like he thinks he knows what the legal definitions of these things are. I don't even know what the legal definition of blackmail is, but I'm assuming that it's having some sort of information on someone and then using it to extort a payment or other benefit from them when you don't have a legal claim to do so. So you would have to have a legal claim, and you would only be able to recover what's appropriate for that legal claim, not something else, not I have a video about you that you're not going to like, so pay me money and I won't post the video. There's a line between simply asking for a settlement of a legal matter, and then there is a line where it becomes extortion. This is not, as far as I can see, anything that goes into a level of misconduct that you could even remotely call extortion. Then there's apparently another video of defendant Carter posting plaintiff's copyright illustration on Twitter on December 11th and stating, "Remember that person? I whooped his ass in court. Your ass is mine, bro." I'm looking at the docket. Like, let's go back and look at the docket here. I don't see where anyone's whooped anybody in court here. They're still responding, and there are attorneys that have entered their appearances. So I have a feeling Mr. Carter really, really, really misunderstands how the legal system works. Doesn't even seem to know the status of his own case. Not that I would expect him to, but it's one thing to not understand the status of your case and just let your attorneys handle it. But then to go in public and just flat out lie about the status of the case, allegedly. That's some sort of immaturity, some level of immaturity that I guess one can only suffer that from having so much money and not having any consequences to being that immature. As a result, plaintiff has requested maximum statutory damages in his motion due to respondent's complete disregard for copyright and the law. Plaintiff is entitled to attorney's fees. If this court determines plaintiff is the prevailing party in this case, it may award reasonable attorney's fees and costs. Defendant's assertion that plaintiff's counsel is not entitled to fees is false. Plaintiff's request for statutory damages and fees based on the facts of a second infringement within 1 month of the registration is valid, I guess. Plaintiff's request for attorney's fees is reasonable. Plaintiff had no option to enforce his copyright but to file the complaint in this case. Despite notifying defendant that his unauthorized use of the illustration was not permitted, then making numerous attempts to engage defendant in substantive negotiation about a potential resolution, defendant chose to ignore plaintiff's claims while ridiculing the legal process. Defendant was properly served with copies of the complaint and summons. Defendant was properly served with the motion for default judgment. After plaintiff has been forced to expend significant time, effort, financial resources prosecuting this case, defendant made the case at the 11th hour that plaintiff's financial expenditures are somehow not appropriate. No, I think Mr. Carter's lawyers made the assertion that the hourly fee and the lack of itemized billing was inappropriate and unreasonable. There's a difference there, and somewhere in there lies the truth. I'm sure that the judge will make note of that in their decision if these parties don't settle this matter beforehand, which they should be able to settle it. If I hear Mr. Carter's assertion correctly, it sounds like there was an offer to settle for $10,000. That sounds like a very reasonable amount for the use, for the publication of the image to 620,000 followers, for the use of the image, not just on the Twitter profile, but also to promote his clothing line. That seems to me to be a reasonable settlement of such a case. I would have counseled Mr. Carter to take that had I been his attorney. But it sounds like egos are larger here and immaturity is greater here than the ability of Mr. Carter to eat crow while the crow is young and tender. And surely he will eat crow when it is older and tougher. This does not mean that the lawsuit is going to become a multi-million-dollar lawsuit or anything like that. Let's temper our expectations. This is just a 5-digit lawsuit over a misuse of someone's artwork. It was probably a 3 to 4 digit damage award before Mr. Carter made it worse, allegedly. And I just don't expect that it's going to become more than a $20,000 lawsuit, really, at the most. So we're not talking about numbers that will break Mr. Carter's bank, but he should maybe learn something from this instead of continuing to assert that Mr. Jödicke is coming at him in some inappropriate way. Very hypocritical response, in my opinion, because what was the original offense? It wasn't like Mr. Carter did nothing and then Mr. Jödicke just attacked him. Mr. Carter used another artist's artwork. according to Mr. Carter's logic there, any one of us could just go use his work to promote our clothing line, and that's supposed to be some kind of compliment. I don't think he would see it that way. I do not think that if we used his artwork in a way that he did not like, that he would appreciate it as a compliment and allow it because of the exposure. But because he's an established artist and he looks, in my opinion, looks down upon Jonas's status as an artist, he thinks that Jonas is trying to piggyback on Carter's work. When wasn't it Carter that liked Jonas's work, not the other way around? It's super hypocritical and extremely immature on Mr. Carter's part. Let's see what else is in here. Numerous federal statutes permit the award of attorney's fees. The court should award plaintiff his request for attorney's fees in full. The plaintiff's attorneys don't really say anything supporting their $950 an hour and $750 an hour attorney's fees. I don't see how that's going to get upheld. Maybe the judge will grant some portion of those. I believe the judge can round it down by 30% without explanation, and it probably deserves to be rounded down more than that. I don't see this as a complicated case requiring a $950 an hour attorney, and it's not that an attorney can't charge that. It's that there's a prohibition against unreasonable fees, both being charged to your client and being charged to opposing counsel when there's fee shifting. So that's the end of that. Considering the defendant's actions and the reasons set forth before, the court should grant the motion for default judgment along with the full request for damages and attorney's fees. I don't think you'll see the attorney's fees award, but you might see the statutory damages award. The argument, and there might even be an evidentiary hearing. The judge might hold an evidentiary hearing to determine whether the infringements were one continuous act or whether they were separate acts. If they were separate acts, then I expect that they will be, the first infringement will be actual damages and the second infringement will be statutory damages and attorney's fees. And if they are one continuous act, then I believe Mr. Carter's attorneys are correct that if one continuous act would be only actual damages and not attorney's fees. However, the actual damages could be high. There will be an accounting. There will need to be a hearing and evidence and discovery, basically a mini trial, all presented on what Mr. Carter's clothing line makes in money, and some disgorgement of profits will be due to using the Brotherhood Two Lions artwork of Mr. Jödicke's to promote that. And whether or not it's a small amount or a large amount will be up to the judge to decide. We've seen maximum statutory damages in the 5 Points case where artwork was destroyed maliciously, and we see that Mr. Carter here has seemingly no remorse, regret, or any humility about this misuse of Mr. Jödicke's artwork. So the judge may very well grant the attorney's fees award and some higher level of damages just as a deterrence to Mr. Carter and other future defendants from disregarding copyright in future cases and in this case. So let me know your thoughts and opinion on that. We'll do a follow-up video as soon as the judge releases the decision in this case, which could come soon. A judge could order a hearing, so it could be much later. This case could go on for another 6 months or a year if the judge orders accounting and a hearing and discovery and sets a schedule for all of that. It could be a rather long time before we hear anything. So we'll keep track of it, and we'll bring that to you when we have it. Let me know what you think in the comments below. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of January: Joe Tyson, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, HotGrillsInYourArea, Torpedan, Brandyn Abel, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, Earthbound Star, Nathan McCarty, and Awful Asses with Lemon Fresh. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.